All right, this week we start a new chapter. This one, all the way in the back of the case book, Chapter 17, Congressional Power to Enforce the 14th Amendment. Now, there's no easy way to approach this topic. You'll notice that Chapter 17 means that we've skipped almost half of the book. This book presents this chapter after it has covered all of the stuff that you will cover in Con Law 2, which is the substance of the 14th Amendment. Other books would treat it differently. If you look at the Chemerinsky treatise, and I've noted the relevant chapters on the revised syllabus, Chemerinsky treats this material along with the congressional material that we've already covered. So he has it just after the Commerce Clause, the taxing and spending power, and the like. So we're going to treat it that way, as trying to understand this chapter as another set of tests and limitations on power that is explicitly given to Congress. The one difficulty, though, is that we will have to approach this without the full background as to what the substance of the amendment means. So let's just look at the relevant text of the 14th Amendment so this will become clear. The substance of the 14th Amendment says this: "No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws." So these headings, and we started to look at the 14th Amendment last week when we were looking at the question of sovereign immunity, and we noted that the court has treated congressional enactments differently for sovereign immunity purposes, depending on whether they were enacted pursuant to the 14th Amendment or whether they were enacted pursuant to one of the Article 1 powers. And we're going to see why that is even more important in the cases for Tuesday and Wednesday. But this provision here, the substantive provision, is very rich in case law, especially interpreting the due process and the equal protection clauses. These will give us the cases. The equal protection clause will give us the cases of Brown versus Board of Education. The due process clause will give us Roe versus Wade. So clauses that have far-reaching effect for individual rights in day-to-day life. So we're not going to cover any of that material. Instead, what we're going to look at is Section 5, hence the name of this separate topic here, the Section 5 powers. So anytime you hear that phrase, Section 5 power, it's always referring to the 14th Amendment, Congress's power under the 14th Amendment. So this provision says Congress shall have the power to enforce by appropriate legislation the provisions of this article. So our study will be trying to figure out what exactly it means, one, to enforce, two, what is appropriate legislation. And then the provisions of this article, again, that's where we will have to move forward with the understanding that we, at this point, don't understand all of the provisions of Section 1 there. And we're going to have to learn a little of it, but just enough to make sense of some of the court's subsequent rulings. So one important point, and so here is a mini lesson on what Section 1 means. One important point, shortly after the 14th Amendment was added to the Constitution, the Supreme Court decided this set of cases called the civil rights cases. And you can see reference to these cases on page 970, note 3. The civil rights cases establish this very famous principle known as the state action doctrine. The state action doctrine is fundamental to Section 1 of the 14th Amendment. It holds that private action is not covered generally by the 14th Amendment. So let's go back and look at the text of Section 1. It says, "No state shall." And then it lists what the states can't do. No state shall deprive any person of life, liberty, or property, nor can any state deny any person within its jurisdiction the equal protection of the laws. So what this means is that no private individual can be said to deprive someone of due process of law as intended by the Constitution or as prohibited by the Constitution. No individual can violate the Equal Protection Clause in their interpersonal individual treatment of each other. So the state says someone cannot go to a state school because of their race. That would be unequal treatment. That would be state action that's unequal treatment. But you say you own a private restaurant, and you say, I don't allow people of a certain race to come into my restaurant. Because you as the restaurant owner are not the state, it's not possible under this state action doctrine, it's not possible for you, the private proprietor, to violate the Equal Protection Clause because it only prohibits state action, not private action. So that's point one about what Section 1 means. Some of you will be familiar with the concept of incorporation. Another important point about what Section 1 means is that the Supreme Court has interpreted the Due Process Clause of the 14th Amendment to more or less incorporate all of the Bill of Rights. If you go back and just glance at the first 8 amendments, the freedom of speech, the freedom to be free of unreasonable searches and seizures. Those, by their text, the Supreme Court ruled in the early 19th century only applied to the federal government. But after the 14th Amendment was adopted, the court said that if any state violates what would be prohibited to the federal government by the Bill of Rights, so if a state were to violate the free speech right or the free exercise of religion right, that would be protected by the Due Process Clause, because although technically only the federal government can violate your speech right, if a state violates your speech right, the court will say that the state was violating your liberty without due process of law. So that's how the Bill of Rights gets incorporated to apply to the states and not just the federal government. So combine those two principles. The 14th Amendment only prohibits action by states, not by private persons, and the 14th Amendment incorporates the Bill of Rights to apply to the states as well. So put those two things together, and it means that only the state can violate the Bill of Rights. Right? So a common misunderstanding that you will see in the press, for example, when let's say that a website disables comments, or let's say you own a Twitter page and you block someone. Frequently, you will hear someone say you're violating someone else's free speech. Well, unless you're the state, that's not legally possible. Right? So again, only the state can violate the constitutional rights that are protected. So the actions of private individuals do not have to conform to constitutional requirements. There are exceptions that I think you will study in constitutional law too. There are a number of, and if you wanted to, you could glance at the Chemerinsky section on state action, but there's no need for us to know it here, but just know that there are exceptions. So this should help to make clearer why a couple of the cases that we previously read were decided on Commerce Clause grounds. So think back to when we were looking at the Heart of Atlanta motel case, the Katzenbach versus McClung case. These were the cases that dealt with the constitutionality of the Civil Rights Act of 1964, in particular, the public accommodations provision. And the book here hints at these cases also in Note 3 on page 970. So Congress prohibited businesses like the Heart of Atlanta motel, businesses like the barbecue restaurant at issue in Katzenbach from discriminating based on race. And remember, we looked at those as Commerce Clause cases, so the court said that if every commercial establishment of this sort discriminate it based on race using the aggregation principle. If every business did this, this would certainly affect interstate commerce. It might make African Americans less likely to travel to these locations, thus affecting all of the businesses in this area. Right? So one question that we had at that time was, well, why did the court use the Commerce Clause? Remember, Congress said that it was passing the public accommodations provision under both its Commerce Clause power as well as its Section 5 power from the 14th Amendment. The court said this statute is easy enough to uphold under the Commerce Clause, therefore we don't have to consider Congress's 14th Amendment power. And at the time, I think I mentioned, that might seem counterintuitive, especially since the 14th Amendment prohibits race discrimination. Why wouldn't the court have looked to the Section 5 powers rather than the Commerce power? And it's because of this precedent. It's because of this state action doctrine precedent that dates back to the 19th century. Because what Congress was trying to prevent was discrimination amongst private businesses, right? The Heart of Atlanta Motel is not the state. Ollie's Barbecue that was at issue in Katzenbach is not the state. And therefore, if Congress wanted to prohibit that sort of action, the court said it was far easier to justify under the existing Commerce Clause precedent, which at that time would have been, for at least 20 years, the Wickard versus Filburn line of cases. Right? Whereas if the court had reached the Section 5 issue, it would have been confronted with possibly having to overrule the civil rights cases, and therefore the court thought it was easier to use the existing Commerce Clause precedent. All right. So the Section 5 power, again, there's the language of the Due Process Clause, there's the power of Congress. Also in the civil rights cases, the court described the sort of power that Congress has. And the court there called this not a power to enact general legislation, but only corrective legislation. And so it's important to understand this by looking at those two clauses. Right? So Congress has the power to enforce this article. Well, what is this article? So this article is Section 1, which is really nothing but a series of prohibitions. Right? So in order for Congress to enforce that series of prohibitions, what Congress must be doing, according to the court in the civil rights cases, is setting out legislation that's not legislating with some big program in mind, like it can do when it enacts legislation under the Commerce Clause. Congress can have a plan for regulating commerce, and it can enact that pursuant to the Commerce Clause. But here, the court in this 1883 case said the most Congress can do to enforce this is pass legislation that would address state violations that are now prohibited by virtue of Section 1. So the court called Congress's power here a power to pass corrective legislation. The court will eventually come to call this sort of legislation remedial legislation, as we see in the Boerne case today. The court will also say that Congress has the power to enact prophylactic legislation. So one way to think of it is the court wants to contrast this power with the plenary powers of Article 1. And this is a more limited power. This is a corrective power or a remedial power. Now, that being said, 100 years later, the court was more attuned to civil rights. And the court said this in a 1980 case. Congress may prohibit practices that in and of themselves do not violate Section 1, so long as the prohibitions are appropriate, as that term is defined in McCulloch. So, although the civil rights cases said that Congress is limited to passing corrective or remedial legislation, the court 100 years later said that legislation, although yes, it has to be corrective or remedial, it doesn't have to be limited to preventing exactly what is prohibited by Section 1. It can be a little more encompassing, so long as its goal is to prohibit the states from violating Section 1. And the court really analogizes this Section 5 to the necessary and proper clause. So the court tells us to think of Section 5 as a necessary and proper clause for the 14th Amendment. So whenever Congress thinks that the state is or is likely to violate due process rights, or whenever a state is likely to violate the Equal Protection Clause, then it can pass legislation that whose goal is to prevent the states from doing that. And an example of this preventative nature or this prophylactic nature is given in Note 4 on page 17. So in 1959, you can see a case there cited Lassiter. The court decided in Lassiter that literacy tests do not violate the Constitution. Literacy tests are not constitutionally prohibited for voting, right? So a state could say you need to take and pass a literacy test before you can vote. But a few years later, Congress passed the Voting Rights Act, and in statute, by statute, Congress outlawed literacy tests. But just a few years earlier, the Supreme Court said that Section 1 of the 14th Amendment does not prohibit literacy tests. So the question was, could Congress prohibit, through its enforcement power, things that the substantive provisions do not prohibit? And the court said yes, Congress could do that. And we'll look at how the court addresses that in Boerne. When is it that Congress can go beyond what is actually prohibited to the states? When can Congress go beyond that in valid Section 5 legislation? So the problem that we're going to be looking at with all of these cases that we're reading is the problem of distinguishing between valid statutes that merely enforce the 14th Amendment and then statutes where Congress gets carried away and attempts to interpret or reinterpret the 14th Amendment from how the Supreme Court has previously interpreted that section. Okay, so let's get to the Boerne case. And then again, this material, not the easiest to follow and to understand, so I'm happy to take questions that you have. I'm happy to have any sort of chats, Zoom chats that you might need to get through some of this material. All right, the background to the Boerne case. Again, we have to understand a little of the substantive individual rights law in order to make sense of any of these cases. And with Boerne, that particular law regards the First Amendment's free exercise clause. So in 1990, the Supreme Court, by a 5-4 vote, decided what at the time was a very controversial case, Oregon versus Smith. Controversial because the court seemed to be reversing its existing free exercise clause precedent. And what the court did is it said that the states do not violate the free exercise clause if their laws only incidentally burden religion, so long as the intent and the effect of the statute is not to discriminate against religion, then it doesn't matter if the statute incidentally burdens religion. So in this particular case, and I think this is explained somewhat in the Boerne case itself on page 972, we had some individuals who belonged to a Native American church. They claimed that part of their religious exercises required them to smoke peyote, a hallucinogenic that was derived from a type of cactus, I believe. And they were fired from their jobs because they had ingested drugs, and they were actually drug counselors. And because they were fired for cause, they were not eligible under state law for unemployment benefits. And their claim was that the state law that prohibited unemployment benefits to them was violating their free exercise rights. And they had relied on precedent that suggested that when a state imposes a substantial burden on the free exercise of religion, then the state is required to show a compelling justification for that statute. So this was the law that existed at the time that the Smith case was heard. Right? So it was fairly easy for an individual to show a substantial burden because the courts really didn't want to second guess someone claiming that their religious exercise was substantially burdened. So therefore, the state was usually in the position of having to offer a compelling justification. And you'll understand this better when you study these individual rights cases in Con Law 2, but it's very difficult for a state to offer a compelling justification because the state almost has to argue that it would be impossible to meet its goal if it didn't punish the individuals at issue here, which is almost an impossible task to meet. So the court overrules, or they don't overrule, but they severely limit, really in a way that's tantamount to overruling, these cases that say that a substantial burden on free exercise must be justified by a compelling interest. And instead, the court says that any burden that is merely incidental does not have to be specially justified. So to put this in more concrete or more recent terms, think of the private baker or florist that doesn't want to bake a cake or make a flower arrangement for a same-sex wedding ceremony. Right? And let's say that violates a state public accommodations law, a law that says if you do business in this state, you can't discriminate based on, and then usually there's a whole list based on sex, based on race, based on sexual orientation. And because the statute was not passed with an intent to discriminate against anyone, in fact, it was passed with an intent to prohibit discrimination, the people who would violate the law, the most they can say is that their religion is incidentally burdened because this is a generally applicable law. Just as someone wouldn't be heard to say, my religion prohibits me from treating black people on an equal basis. The same baker or florist would not be heard to say, my religion prohibits me from treating same-sex couples on an equal basis. So that's how this impacts things that are going on today. So Congress dislikes this Oregon versus Smith ruling, and the ruling was interestingly universally condemned by just about every political organization at the time. So you had the right-wing religious groups teaming up with the left-wing civil liberties groups. And the result was a statute that came out of Congress that passed unanimously in the House and overwhelmingly in the Senate. And this was known as the Religious Freedom Restoration Act. The idea was to essentially undo Oregon versus Smith. And you can see the book quotes, or the opinion here quotes the findings of Congress on page 973. So you can see there's some findings 1 through 5. Congress notes that Employment Division of Oregon versus Smith, the Supreme Court virtually eliminated this requirement that the government justify burdens. And therefore, the stated purpose was to restore the compelling interest test set forth in Sherbert versus Werner. This was the pre-Smith case law. So it's pretty clear what Congress's goal here is. Congress's goal is to undo Smith and put in place of Smith this test that the court had used in prior case law. So how does the Boerne case arise? So Boerne arises when a church in Boerne, Texas wants to expand its physical facility. At the time that the case is brought, the church has seating for about 230 congregants, and they want to expand their seating to 700 seats. Because this was a very old church, the church had to apply for a building permit with the city's Historic Landmark Commission. And the Historic Landmark Commission denies the permit. They say that the church is one of the things that defines the town. This is our postcard that we use for the town. So this was a generally applicable statute. This was not the historic landmark legislation was not designed specifically to discriminate against churches. Everyone had to comply with the historic landmark rules and zoning permits, the building permits. So the most the church could say is that their religion was incidentally burdened by this historic landmark commission legislation or this particular finding. Under RFRA, because the church claimed that it was substantially burdened, if RFRA was to stand, then the city would have to demonstrate a compelling interest in denying the permit. That would be very difficult because the church claimed that it would keep the facade, but it wanted to essentially gut the church. And so everything behind the front would be eliminated. And you could easily imagine the city then failing, because if the city's main argument is that the church was an icon and the town was recognized by the church, then if the church promised to keep the facade, you could imagine a court saying, well, that's good enough. That meets what the city's concern is. But under the Smith test, the burden is not on the city. The burden would be on the church. And what the church would have to show is that the city's action lacked any rational basis whatsoever. The reason that this is such an important issue to decide at this point is because determining which standard of review governs is essentially to determine the outcome of the case. Because it's almost impossible for a government to prove a compelling interest. And it's almost impossible for a private litigant to show that the government lacked a rational basis for its decision. So therefore, to decide the level of review is essentially to decide the case. Right? So that's why this fight is so important. Here's a picture of the church. So you can see the Historical Landmark Commission. You can see the rational basis, I think, just by looking at the church. It looks like a very nice church. If the city says this is, people see this and they know, that's Boerne, Texas, then they clearly have more than a rational basis to deny a permit that would involve altering 80% of the church, I think is what the church said. So we see what the statute does. The statute wants to employ this compelling interest, this substantial burden compelling interest test, and get rid of the rational basis test that Oregon versus Smith had adopted in its place. So is RFRA, the Religious Freedom Restoration Act, a valid enforcement of the 14th Amendment? So what should we do in analyzing this question? If we go over to page 947, we can see the court starting to discuss its method of analysis. So the court starts by quoting Section 1 and Section 5 of the 14th Amendment. So the argument is, looking at Section 1 prohibits a state from depriving any person of life, liberty, or property without due process of law. And we know that the Free Exercise Clause is incorporated to apply against the states via the Due Process Clause. So essentially, we would argue that the state, in this case the city of Boerne, Texas, is depriving this church of liberty, the liberty to exercise their religion freely without due process of law, and therefore Congress has the power to prevent or to remedy instances of Section 1 violations. Right? And so that's what Congress is claiming to do here. According to Congress, the city of Boerne would violate the 14th Amendment and the First Amendment by prohibiting the church from engaging in this expansion, and therefore the city would have to justify its actions in order for them not to be a violation through a compelling interest, which again would be very difficult to do. So the court says when Congress attempts to enact a Section 5 statute, it's going to have to identify which part of the 14th Amendment it's claiming to enforce. And here it's claiming to enforce the Free Exercise Clause that's incorporated through the Due Process Clause of the 14th Amendment. So what is the evil that the law is seeking to remedy? Because remember, the court since the 19th century, since the civil rights cases, the court has said that Congress's power is a remedial power, right? It's a power designed to correct bad actions in the states. Right? So the 13th, 14th, 15th Amendment are the Reconstruction era amendments. These are the amendments that are designed to, in essence, punish the southern states as they come back into the Union. They are designed to list all of the bad things that the southern states had done, slavery in the 13th Amendment, all of these things in the 14th Amendment, voting rights in the 15th Amendment, and they're essentially a list of things that the states cannot do, and Congress is given the power to make sure that the states don't do those things. So isn't that what Congress is doing here? Doesn't Congress see a state behaving badly, and Congress is trying to prevent that or to remedy that? And the court says we have to be very careful that in claiming to remedy 14th Amendment violations, Congress is not actually changing the substance of what the 14th Amendment prohibits. So there is a test that is given here, and the test comes at the bottom of page 975. And this becomes known as the congruence and proportionality test. The court says in that last paragraph, there must be a congruence and proportionality between the injury to be prevented or remedied and the means adopted to that end. So if the Warren Burger courts were more expansive or more solicitous of protection of civil rights, developing that essentially necessary and proper clause understanding of Section 5 of Congress's enforcement powers, here the court seems to be narrowing slightly this means-ends test, and it calls this a congruence and proportionality test. So what is meant by this? Now, this is perhaps one of the most difficult things to try to understand just from this case itself. I think the court starts to further explain this test in the cases that we'll look at on Tuesday and Wednesday, but this is not the clearest test that the court has ever developed. In fact, one of my colleagues at SIU clerked for Justice Kennedy, who writes this majority opinion, and he says that this is impossible to decipher because no one really knows what Justice Kennedy meant by this particular sentence. Again, the court as a collective starts to try to unpack this in subsequent cases, but let's see what can we make at this point of these two concepts of congruence and proportionality. So I think for congruence, we can try to figure out what it means by asking these questions. What Justice Kennedy is concerned with here in asking about congruence is the fit between the statute and the injury. Does RFRA fit, or does it correspond to some particular injury? Right? And in looking at this, Justice Kennedy examines the congressional record, and he asks, what evidence does Congress have that there actually is some constitutional injury that needs to be remedied or prevented? And he doesn't really find much here, right? He doesn't find much in the congressional record. Right? So this is over on, the discussion is bottom of page 979 to the top of page 980. So when you look at this discussion here, we see what look like two problems. He says, so he's discussing the hearings on the Religious Freedom Restoration Act, looking at what Congress was concerned with. And he says, sort of near the end of that page 979, he says, it's difficult to maintain that these are examples of legislation enacted or enforced due to animus or hostility. In other words, the things that were being pointed out in these hearings as what Congress was concerned with, Justice Kennedy doesn't see those particular statutes as being evidence of animus or hostility. Congress's concern was with the incidental burdens imposed, not the object or purpose of the legislation. He further says, this lack of support in the legislative record, however, is not RFRA's most serious shortcoming. So I think we can interpret this as being the explanation that there really is a lack of congruence here, right? The injuries must be the injuries that you can attribute to Section 1, the no state shall, right? And what you have to appreciate here is that Kennedy is saying that Congress can't ignore Smith. Smith sets out what constitutes a free exercise violation. And free exercise violations are only those things that occur when legislation is passed out of animus or hostility to a particular religious group. So long as you have a generally applicable statute, like everyone must serve every customer that comes in through the doors without regard to race, religion, sexual orientation, gender identity, that sort of general statute, that is not a statute that violates the free exercise clause, because that is not a statute that was designed or written just to discriminate against religious groups. And therefore, what Kennedy is saying is that this is not the sort of problem, or these statutes identified in the legislative record are not the sorts of things that in and of themselves constitute free exercise clause violations, right? So that's another way of saying that there really isn't an identifiable injury here for Congress to even remedy. But Kennedy says that that's not even the most serious shortcoming. The most serious shortcoming comes in the proportionality analysis, which starts at the top of page 980. That first paragraph, RFRA is so out of proportion to a supposed remedial or preventative object that it cannot be understood as responsive to or designed to prevent unconstitutional behavior. Right? So here we ask, is the statute proportional to the evil that it identifies in the first inquiry, in the congruence inquiry? Is the statute limited to remedial measures, that is, correcting bad things that the states have already done? Or is it preventative or prophylactic? Is it trying to prevent the states from doing those bad things before they do them? And here, Justice Kennedy calls this so out of proportion. It's really, the whole thing is out of whack. And why is that? Well, let's look at the next paragraph. RFRA is not confined, he says, and he's comparing this to the City of Rome case, which is cited in the above paragraph, comparing it to past cases where the court has upheld preventative or prophylactic measures. So what about RFRA is different? Sweeping coverage ensures its intrusion at every level of government, displacing laws and prohibiting official actions of almost every description and regardless of subject matter. RFRA's restrictions apply to every agency and official of the federal, state, and local governments. RFRA applies to all federal and state laws, statutory or otherwise, whether adopted before or after its enactment. RFRA has no termination date or termination mechanism. Any law is subject to challenge at any time by any individual who alleges a substantial burden on his or her free exercise of religion. So, in other words, the statute which restores or attempts to restore this old or this pre-Smith compelling state interest test burdens the states by forcing them to show a compelling interest whenever anyone claims a substantial burden of religion, applies to everything. right? So what Kennedy envisions here, and this really gets to the nature of the remedial power, right? What Kennedy says is Congress has to be very specific. It can't just say, we see a problem with states violating people's free exercise rights, and therefore we're going to pass a law that says the states must show a compelling interest every time someone asserts a substantial burden. Justice Kennedy says that is far too vague of a statute. What Congress would have to do to provide us with a statute that is more congruent and more proportional is they would have to tell us specifically where do you see free exercise violations, keeping in mind the way the Supreme Court has defined free exercise violations. Do you see it with respect to zoning practices? Do you see it with respect to building permits? Do you see it with respect to unemployment benefits? And then the remedy, how is the remedy specifically tailored to that sort of injury? And instead, Kennedy sees just a blanket law that covers every possible state action and applies anytime someone asserts a substantial burden. Right? And Kennedy, in the next paragraph on page 980, says, well, let's look at these instances where we have allowed Congress to enact preventative remedies, that is, statutes that apply to state action before the state has actually done something wrong. And he says these have tended to be areas where there's a historical record of bad acts by the state. So he refers to some of this voting rights legislation and talks about the example of literacy tests being held to be not violate the 14th Amendment and 15th Amendment, but then Congress prohibits them through legislation nevertheless. And Kennedy says, at least in that instance, Congress found through its legislative findings that literacy tests had a long history of being used to discriminate based on race. Whereas here, one, the statute is not limited to one specific thing like a literacy test. This applies across the board. And it's not limited in time the way that the Voting Rights Act was, or geographically. So look at the bottom of page 980. He talks about termination dates, geographic restrictions, or egregious predicates, right? All things that the Voting Rights Act had in it. It has expiration dates. Congress can renew it. It, in certain instances, applied only to the southern states because Congress said those were the states that had the existing or likely violations of the 14th Amendment. And it had egregious predicates, so states weren't subject to this statute unless they had a history of discriminating against race. Right? None of those things were in RFRA. RFRA, again, just applied across the board without any demonstration that these problems existed equally in every state on every possible topic of legislation. So the congruence and proportionality then, here no evidence in the legislative record that there is such a widespread problem of states interfering with religious freedom. Even if there was a problem, the statute, according to Justice Kennedy, is sweepingly broad and undifferentiated. Again, it applies to every single thing that a state could possibly do. Right? Someone could challenge every state action as severely burdening their religion. Right? Instead, well-proportioned legislation is going to show how it is designed to address the problems that are identified and only those problems. And notice the bigger themes that are at issue here. We get to see both themes that we've studied this semester come together here. there's the separation of powers theme and the federalism theme. So we see this over on page 981, and I think the court actually talks about them in the reverse order than I have them here. But let's look at that first full paragraph on 981. The court says, bottom of that first full paragraph, because of this statute applied so broadly and in an undifferentiated manner, the statute would require searching judicial scrutiny of state law with the attendant likelihood of invalidation because of that compelling interest burden that most states would not meet. This is a considerable congressional intrusion into the state's traditional prerogatives and general authority to regulate for the health and welfare of their citizens. So we see the basic theme here. Congress's powers to override state laws should be limited, a federalism concern. And then we also see a separation of powers concern asserted in the first half of that paragraph, where the majority here sees this attempt, this RFRA, this Religious Freedom Restoration Act, as an attempt to undo Smith, as an attempt to undo the court's decision. So Congress should not be allowed to alter the meaning of a right that was previously defined by the court through ordinary legislation. Right? So the court sees Congress as attempting to reinterpret what it means to violate the Free Exercise Clause, what it means to violate the Due Process Clause of the 14th Amendment. And Congress is trying to do this not through a constitutional amendment, but through an ordinary piece of legislation like RFRA. And therefore, we might say that this is an interference with the most basic command that we studied the very first day of class, the Marbury command, that it's the province and duty of the judicial department to say what the law is. So we see a separation of powers problem here then, with Congress attempting to go beyond its enforcement power and move in to the interpretive power that should belong to the court. Right? It's clear that Congress was unhappy with Smith, but the solution is not to attempt a reversal of the court's interpretation of Section 1 of the 14th Amendment with a piece of legislation under the guise of Section 5 of the 14th Amendment. Right. So, as the court says here, Congress can pass remedial legislation. Congress can also pass preventative or prophylactic legislation. It's just that the more far-reaching that the legislation is going to be, the more it needs to be tailored to the particular problems that Congress sees existing in the states. Right? So, Congress somewhat takes this lesson to heart, and when we get to the cases on Tuesday and Wednesday, we'll see the interaction between Section 5 powers and 11th Amendment claims of sovereign immunity. So we'll come back to the material that we looked at last class or last week. Yes. So if there are questions, and I'm sure there will be about this material, they might not all be answered in this first reading, but hopefully will become clearer as we go throughout the week. But again, I'm happy to address particular points of confusion now.